Now I have
Tell the intern to note it. Tell the intern to note. Yes. Your written note of submission is there. Let us quickly run through it
yes, sir.
to get a idea about it. Quickly run through.
Your
Ah,
Lordship,
that helps.
kindly see the particular document which I have, there is note for clarification, fact, and terms for better appreciation of the Honorable Court.
Yes.
Here, my lord, the reason of death has been shown as asphyxia.
Yes.
Now, my lord, asphyxia has been stated to due to lack of is because of due to lack of oxygen in blood and due to suffocation.
Hmm.
The meaning of the dictionary, the brief case that appellant Narahari got married to the deceased.
Hmm.
Then he stated that at the time of marriage, acquisition was demanded for 2,000 rupees and gold, ornaments, wooden almirah and palace. However, the father of the deceased could not fulfill the demand. After the marriage, the witness states that the accused person tortured the deceased and ultimately the deceased died. Here I may point out that there is no supporting evidence with regard to this fact.
Right.
Now, asphyxia, I have made a clarification about asphyxia. As per Britannica, other concerns lack of exchange of oxygen and carbon dioxide to reciprocate failure or disturbances in brain result in suffocation of oxygen leading to unconsciousness or death. After marriage, Narahari came to came to her in-laws' house, and at that time relationship was good. It is submitted independently. That is, good means there was no problem with regard to dowry. There is only a concoction.
But you have been convicted for 498A also, section 4 also,
Yes.
and 304B.
Yes, you know. It is submitted that independent asphyxia cannot be caused. Certain criminal means and by means of such culpable action, asphyxia can be caused. No such action has been settled by the prosecutor.
Right.
There is no evidence that the accused person either orally or criminally acted committed any such action which suggestive of asphyxia has been caused. He had no role, there is no evidence that he is part of assault. Assault was by other person creating asphyxia. Now kindly see, before the incident, before 2 days of the incident, this lady had gone to her father's house. This lady had an infamous idea about her character in the people, public. It was public, very much public. So anyway, she has been summoned by her brother to their village, and they had given some assault. Assault was by other person creating asphyxia. They had done it. Therefore, the trial court has committed gross error of law, etc. Next place, because of his failure to split the two parts of the evidence. One, the action which led to cause asphyxia and the death. Petitioner cannot be implicated. There is no evidence to the regard according to petitioner may be acquitted and set free. Gayadhara Das, father of the deceased Koike Das, went to daughter's place with marriage proposal through the middleman. It was decided that 2,000 rupees in cash, one tape recorder, one almirah, one cut, and some household materials were agreed to be given. For the same, jawab was given. However, at the time of marriage, besides the palanquin and almirah, everything else was given, and it was promised to give the remaining items after some time, and this was decided and settled through middleman, one Bhaskara Basal, and marriage was completed. It was known as priest Nityananda Prabhakara and Barika Prabhakara. Immediately after marriage, in father-in-law's house, she was very disgusted. This was known to her eldest brother Surendra Kumar Naik. The father going to daughter's house learned that as the dowry item was not given, his daughter was beaten up and abused in filthy language. He went to daughter's house on 8/1/19 with his family.
partly argued, na? No, Miss Dolo has argued, na? Awesome, awesome. Okay. 94. HS Mishra. Last time he's taken, na? Not at Janet, huh? 94, 94. Lot of matters on 94. Item 4. Item 5.
4, 5, 6, 2 times.
Higila.
94. 4, 7. Chapter.
No, what about 5?
5 नहीं. अपन one about
Yes, Sahu. One of the appellant has died, huh?
अपन one.
Yes. 6.
अपन do that.
Yes. These people, you just call them. Otherwise, you will appoint. Yeah. 94. There are many matters of 94.
एक touch.
Huh?
We challenge touch. That's so.
Yes.
8, 9, 10.
8, 9, 10 is over. Then 7, 7 partly hurt.
7 part.
Then these 3 matters. 3, 4, 5, 6.
4, 5, 6.
4, 5, 6.
Item 9, my lord is right able to file a written note submission, my lord.
Yes.
Unfortunately, I took in the pen drive, but there is nothing.
Why? Just check it out.
What do
I took yesterday, but there is nothing in this pen drive. I made
Now, once again,
permitted to take it.
you help him. Dekhi.
In course of the day, or I will file.
No problem. No. These 3 matters, you just check it up and call them. 94, so that 94 will be over. Then we will cover till 94. Then 95 will remain. Okay, 95, how many matters? 2, 3, 4, 5, 5 matters.
Chapter. 4 meters. Chapter.
4 matters, okay. 4 matters. So let us concentrate on 94. And small matters, 2 o'clock, if nobody is there, just see what are the sentences. And these people are there, I have to appoint them.
20.
Appoint them.
If it should be taken up now,
Just see, Shubhalakshmi, you also just check it up. Small matters, the heavy matters are there. 1, 2 heavy matters, 1 we can take. But the small matters we can very well finish it up. 6 months, 3 months, and all. This is the list. Just check it up, see the file, and we'll appoint MKS Kuri if they're not there. See, these people are there. We can appoint someone and check it. Okay, great.
Item 7.
Wait, please, Your Honor. Here, in fact, the case was argued by both of us, but question crops up during course of hearing that
Repeated-
whether you
Repeated assault.
yes, a person having sustaining 12 injuries,
Hmm.
you would have sustained 12 injuries and different parts of the body,
14 injury.
14 injuries.
Hmm.
So whether case can be converted to one under 324 or 325 or not. Well, it is to be seen at the very first instance whether the injuries, what is the opinion of the doctor pertaining to the said injuries,
Hmm.
because that has been observed by the apex court.
Yes.
Before going to the judgment, I want to say, draw Milet's attention. What is the opinion of the doctor pertaining to the said injuries? Millet, page 53, PW7.
Yes.
PW3 has sustained around 14 injuries, Millet.
Hmm.
Different parts of the
Yes.
body, and out of the injuries number 1, 8 and 10
Or grievous.
are grievous in nature. But let me see the cross-examination part. Individually, none of the injuries were fatal in nature. I instructed to give the wearing apparels of the injured to the police. OIC town PS brought the injured to the hospital and identified to me. It is not correct to say that the injuries are not possible by MO1. All these injuries can be possible by fall on broken glass, but not by a single fall.
Hmm.
I did not notice any injury on the middle of the head. The injuries are not on vital parts. X-ray was done as per my advice. I referred to the X-ray plates at the time of treatment. Dr. Tripathi has scribed the observations with regard to X-ray plate as per radiologist opinion. There was no bony injury on the skull as per radiologist. This much, which shows
There is nothing, say that in the ordinary course of nature
to cause death.
is likely to cause death.
If it would
That
have,
sentence is not there.
yes, that
And-
sentence,
and
that
the
sentence is
Contrary to that, it is not fatal is there, not in the vital part is there.
valid.
Contrary to that.
Yes, injuries are not on the vital parts,
Not vital part,
and no
these
X-ray,
are not fatal.
and the X-ray plate has also not been produced.
And Tripathi is also not examined.
Valid. Dr. Tripathi has not been examined.
Hmm.
On this score, with this background,
Hmm.
I want to show some decisions.
Yes.
Hmm?
Yes.
Valid. Here, paragraph 8.
10, huh?
8 valid.
8.
8 paragraph.
Yes.
Judgment.
Justified.
Yeah, valid. To the 2008, volume 39 OCR, page 93. On perusal of the evidence, it is seen that injury.
You are reading the first one, huh?
First one.
Okay.
2008, volume 39 OCR,
Okay.
page 93.
Yes. 39.
On perusal of the evidence, well, you got it.
On perusal of the evidence.
It is seen that the injury certificates of PWs 1, 2, 4, 8, 10, and 13 are respectively exhibits 2, 7, 4, 6, 5, and 3. So far as the injury of PW2 is concerned, besides the evidence of the doctor, PW6, it appears from the evidence of the referral doctor, PW12, and his report exhibit 10, there was fracture of proximal phalanx of right ring finger. Similarly, in case of injuries of PW10, evidence of Dr. N. Narsinga Rao of VSS Medical College, PW15, reveals that there was fracture of patella of right knee joint and there was no other fracture injury on the body of PW10. It reveals from the injury certificates exhibit 2 or to 7 that all the aforesaid injured persons sustained injuries like bruises, abrasions, lacerations, wounds, except in the case of PW4, who had received one incised wound over left eyebrow. The incised wound was of dimension of 1.5 inch into 1 inch into 4 inch muscles deep over left eyebrow. That injury was also described as simple in nature. It is thus found the record except the bone fracture injury of each of PWs 2 and 10.
Next paragraph is important.
Well, I'm
correct.
coming to that. Well, I was
That I
just
read it.
I was-
Mere injuries are not important.
injuries are not important, and it is to be seen which part here, my lord.
Existence of an injury, simple or grievous,
My lord.
is not to be the reason to convict
My lord.
307.
My lord.
Mere existence of the injury.
My lord,
You have
paragraph
to
10
see-
is,
yes.
it is stated at the bar that accused persons were inside the jail custody for 15 days after the judgment was pronounced by the trial court and before they were permitted to go on bail by this court, and then counsel for the appellants argues that the occurrence has taken place in the June 1987. A substantive sentence after 20 years would cause serious difficulties and therefore lenient view may be taken and a sentence of fine may be imposed. The additional standing counsel, however, rightly argues that so far as the offence of the 325 is concerned, there cannot be alone be a sentence of fine. On due consideration of the facts and circumstances and the aforesaid conviction of the appellant, each of the appellants is sentenced to pay a fine of rupees 100 for the offence under 148 and in default to undergo simple imprisonment for 1 month. Similarly, each of the appellants are sentenced to pay a fine of rupees 100.
But the real ratio of this case is the mere presence of the injury is not important.
Not important.
You have to see the intention
Intention.
from the evidence of
Yes,
the
yes,
victim
yes.
as well as the doctor.
My lord.
That's
That-
what
That
the
has
issue
also
is.
been observed by Honorable Apex Court.
Hmm.
Next judgment by Honorable Justice Deepak Mishra, my lord.
Yes.
By Honorable Justice Kirti Singh, sitting with
Justice Kirti Singh.
my lord. Here also case of 307 converted to 1 under 325. Principally same, my lord.
Yes.
Next judgment is ballot by Honorable Justice Iqbal. 2016, volume 15, SCC 752. Ingredients to justify conviction under 307, absence of conviction altered from 307 to 325, conviction under 450 to confirm.
Which paragraph here? This is very
My lord,
important.
yes, it had Honorable Court was pleased to discuss
This is
in
Nagappan.
paragraph 9, my lord.
Nagappan. Hmm. Just before the occurrence.
Just before the occurrence, PW1 Monu Lal came to the fire station for surprise check and recorded the absence of the accused in the general diary. Within few minutes, the apparent accused armed with lathis went to the house and indiscriminately beat him with lathis, causing injuries in neck, chest, hands, buttocks, and thighs. PW3, Dr. ND,
18 injuries.
18 injuries.
They were not in vital part of the body.
My lord. In fact,
The
the
two that-
grievous injuries are the fractures of wrist bone in both the hands. Though the injuries caused were
Yeah.
18 in number, they were not in vital parts of the body. It is true that the appellants had acted in state of fury, but it cannot be said that they caused
an
those
intention
injuries
to
with
cause death.
intention to cause death.
So number of injuries are irrelevant.
My lord. Another case, my lord, Honorable Justice S.K. Sahu, Honorable Court was pleased to take note of a judgment of old judgment, 63, volume 8, SCD 208,
Hmm.
and quoted the same. It has been referred in paragraph 11. Well, let me see.
Settled principle of law
My lord.
to justify the conviction.
Which my lord was now referring,
Hmm.
but with the case of 307. It is not essential that
Bodily injury capable of causing death.
death should be
And
inflicted.
that could be
It is not essential that bodily injury capable of
and that has to be borne out from the evidence of doctor.
My lord, the nature of injury actually caused very often gives considerable assistance in coming to a finding relating to the intention of the accused. However, such intention can also be deduced from other circumstances without even any reference to the actual wounds.
Yes, I got it.
My lord.
And what you see, three things have come from this judgment. First one is number of injuries are immaterial. Second one is for 307, intention is must. Third is the element of the intention leading to the murder of someone, to killing someone, that has to be there. But in the doctor's evidence, all the three things are absent. Rather than the contrary, the doctor says it is not on the vital part, the injuries are not fatal.
Yes, sir.
My humble prayer,
And no opinion that in the ordinary course, these injury may cause death. in the absence of all this, how 325? And
First of all.
My lord, one thing I want to say here, in all the cases I was going through, case has been taken off, appeal has been taken off after 10 years or 15 years or 20 years. Here in our case, it's more than 30 years.
So probation,
My lord, maybe provision, maybe fine may be enhanced.
like, fine may
And
47 days.
he was in custody for around 47 days. My lord.
47 days undergone. Fine also we can.
My lord,
impose.
my lord. That is to be.
First of all, to support the conviction for under section 307, intention and knowledge is the lots of the first part, you also to find out the.
Where
evidence.
from evidence, where from
To
you getting?
with the eyewitness to the occurrence is clearly stated the implication of the present appellant, your lordship. Appellant number 2 has died, his court hold, and appellant 1 has assured the.
That's right, but
But I'm coming to lordship.
Hmm.
And there is the evidence of 2 and 3 corroborated by the doctors. Your lordship
who is the injured?
Lordship kindly glance the evidence of the period 2 years.
What does he say? One second, please.
Period 2 year also page 41 year also. Pradeep Swine also. 4 lines go top bottom also.
Hmm.
They, my elder brother towards the Delhi market road, Raghava told to my brother and Madhu.
That is not disputed.
Sir, I'm coming to the.
Where from will get intention?
How the manager of the cinema hall has said that police asila they were following Pune asigal. I'm only to bring the intention knowledge of the appellant.
Intention is to cause grievous hurt. That is 325. That we concede that.
Lordship.
Intention to kill. Where is that intention to kill? If that would have been the case, they would have given the blow in the fatal vital part. That is not there. Doctor says no vital part. Injuries are not also fatal.
My lordship, I have come in Supreme Court judgment. Lordship, even if the injuries are not in metal part, lordship.
But intention, if the witness have said that somebody that is Lalkara witnesses are there, kill him. Somebody is saying kill him. Thereafter the attack is there. Because of that Lalkara witness, the intention is imputed. That's the judgment of this. Where is the Lalkara? There is nothing.
Kindly grant your lordship, I relied on appeals court judgment, your lordship. Page paragraph 14, your lordship. In this case, what happened?
Anybody has said that kill them. Where is that?
Intention, your lordship, the manager of the cinema hall, while they asked the police, they have accused person have fled away. Again, the no asked, police no asked, again, come and assault the present victim.
Assault corruption.
That is the intention.
That is why they are to be convicted in 325.
And so, my lordship,
What you are trying to say is that again, second time they came, therefore the intention has to be inferred. In criminal jurisprudence, there is nothing like inference.
Intent, I am not.
Can the intention be inferred? Because they came second time?
By way of the evidence that has clearly made out that there is an intention of the.
Where is that? Show me.
Placing the entirety of the PW2, your lordship, kindly grant.
No inference in this jurisprudence.
Lordship, kindly.
You have to say that they have come again to kill us. If that is there, the evidence, then one can understand, yes, they came to kill us. That is not there. None of the witness says that they have attacked us to kill. Attack is there, therefore 325. And that again the doctor says not in the vital part. The injuries are not fatal. And you have not put that question that in the ordinary course of nature, these injury may cause death. Have you asked this question? Then?
Even if the injury are not in the vital part, your lordship, lordship, kindly grant.
Which paragraph?
Judgment, paragraph 14, your lordship.
14.
In this case, what happened?
1-4.
Yes, your lordship.
Hmm.
In this case, what happened? Accused 4 appellants are paid the trial for commission of 307. The London Trial Court is sentenced to 3 years.
14, read it.
Lordship, I am relying.
What first line?
Of the case, yes, right.
First side.
The High Court.
Why do you cite a case which directly goes against you? Read 14.
Yes, I am reading.
Read. Read.
The High Court was of the opinion that the injuries have not been caused on the vital parts of the body.
Vital part.
They are coming, Lordship. In your two.
Your doctor says no, not in a vital part.
Lordship, I am coming. In your In this case, what happened? The London High Court has sentenced 3 years lordship. The appellants challenge for the Honorable Appeals Court, Honorable High Court, Madhya Pradesh. Madhya Pradesh High Court has allowed the appeal of the appellant and period honorable. That was challenged by the state of Madhya Pradesh for the Honorable Appeals Court. Appeals Court has that is the objection. I am placing.
Yes.
In order to attract the section 307, the injury need not be in the vital parts of the body.
Hmm.
In order to attract section 307, causing of hurt is sufficient. If anybody does any act with intention or knowledge that by this act he might cause death and hurt is caused, that is sufficient to attract life imprisonment. Section 307 uses the word hurt, which has been explained in section 319 IPC and not grievous hurt within the meaning of section 320 IPC. Therefore, in order to attract section 307, the injury need not be in the vital part of the body. A gunshot, as in the present case, may miss the vital part of the body, may result in a lacerated wound. That itself is sufficient to attract 307. The High Court is therefore in error in reducing the sentence, holding that the injury was not a vital part of the body. Period undergone by way of sentence also in our view is not commensurate with the guilty established. In this case, so the Honorable High Court of the Madhya Pradesh.
Come to para 5. Reading.
The trial court, after appreciating the entire evidence, held as follows.
Hmm.
In the night at 11 o'clock, coming of the accused person equipped with weapons and firing at the informant side, not only once, but rather several times,
Hmm.
don't show without any provocation, and at that time of occurrence, their intention also that killed all of them. Suggests this common intention of the accused persons that in reality the intent of the accused person was to kill the informant side. In such circumstances, for concluding the intention of the accused persons, the selection of the
Selection of the vehicle,
used in the crime
weapon used in the crime,
by
they are important.
very important, which is the circumstances of the present case. A gun, and according to the report, the pellet
One barrel
has
gun.
been examined. This can
Would
be
even the
found
examination
from
of
article
features.
A1 and 1 barrel gun
Yes, I think.
of 12 bore.
But,
Even the examination of which has been done by the assistant chemical examiner and the senior scientific officer. According to that, it was in the operative condition and from the residue found in the barrel of which the presence of nitrate has been found. To be positive, which shows that this gun has been used, and although conclusively that can be said that when it has been used for the last time, because scientifically it is not possible to tell this with certainty. In my respect, submission also, even if the injuries are not the vital part, and hot is not defined in 1920, is clearly made out, and by corroborating the evidence.
But the fact of this case is completely different. Here they came with in a vehicle in the midnight with gun and barrels and all these things. So therefore, the court says that there was intention, selection of the vehicle, selection of the weapon of offense, and all these things, and the timing.
The ratio
And
is
because of
ratio is that
and they came with a there is a difference in a spur of moment. If an incident happens, somebody pulls up something and beats up. That's one situation. Another situation without any provocation, with a plan in a vehicle, coming with the gun and barrels and nitrate powders and all. From there, the trial court says that there is an intention. What was the provocation to come in the midnight with a vehicle, with all arms and this thing, ammunition? There is only two intention to kill. So therefore, the trial court says there was an intention, which was converted by the High Court. Period undergone. That matter went to Supreme Court, and the Supreme Court says that no, it is up 307 because the timing is important, and the selection of vehicle and the arm and ammunition are important. But what is the fact in this case?
in this case, Your Lordship, the victim injured and the brother of the injured was clearly stated the assault and intention knowledge of the present appellants in order to commit the murder, Your Lordship, kill the That's why I'm pressing the PW proof statement again.
I read it.
To inform you or
I read it.
To bring the intention knowledge, how the Lordship, person, I managed to escape. The last three lines about in the page 41 also.
Yes.
I managed to escape and went to Borivali for the house of my cousin brother. My brother sustained several injuries, and there was a profuse bleeding from his wounds. I cannot give the number of the seat fulfilled in the cinema hall by us. I cannot say whether the resource and contribution. All the features were also and that there is scheduled free also. Victim who is the victim in this case, injured also. I read 43 also.
Yes.
Schedule 3 also. Injured also.
Injured, I read the.
The accused Raghav. Raghav was died during pending the appeal. But told to me and other accused means the present appellant Madhavananda Pradhan dealt to Tribujaris close on my body. However, I tried to extricate myself from the clutches of the accused person and managed to come away and enter inside the cinema hall premises. When the assault was made by Bujali inside the cinema hall premises, I fell down on the ground. They also assaulted me further even after fell down on the ground. It sustained several injuries and different parts of the body. I was treated in the hospital for 20 days of hospital.
Okay.
Another judgment, relying the another judgment also. Paragraph 9 of the judgment. Paragraph 9. Para 9 of
9.
That's it.
Yes.
May I read it?
Hmm.
It is sufficient to justify conviction under section 307 if there is present in intent coupled with some overact in execution there. It is not essential that bodily injury capable of causing death should have been inflicted. Although the nature of injury actually caused may often give considerable assistance in coming to finding as to the intention of the accused. Such intention may also be deducted from the circumstances and may even in some cases be ascertained without any reference to all to actual wounds. The section makes a distinction between the act of the accused and its result, if any. The court has to see whether the act, irrespective of this result, was done with the intention or knowledge and under circumstances mentioned in the section. Therefore, it is not correct to accuse the accused of the charge in 207 IPC merely because the injuries inflicted on the victim are in the nature of simple harm. I'm relying in supporting my claim that the conviction is rightly
And one judgment I want to add of Honorable Justice Hidayatullah, where 17 injuries were there. My learned friend that has raised. The appellants along with Basanti Mandal are said to have attacked one Ramadin Mandal with diverse weapons such as farsa, spear and lathi, and to have caused to him 17 injuries consisting of incised and punctured wounds and bruises. Medical evidence shows there were 8 injuries by farsa, 3 by spear, 6 were bruises and abrasions, presumably caused with lathi. None of the injuries, however, was grievous, and only 2 of them are located on the head and neck. The one of the neck was cut skin deep, along with it was 2-inch long and 1/4 wide. The injury on the head, which was presumably given with farsa, was 5-inch in length and 3 by 4 inch wide and was bone deep. The others were located on arms, legs, and on the backs, but none of them had either caught any important blood vessels or injured the bone, and most of them were superficial. Medical evidence did not disclose that any of the injuries were cumulatively dangerous to life, and the question, therefore, is whether in these circumstances it would be held that the offense disclosed was one under 307 of the Indian Penal Code. That section requires that the act must be done with such intention or knowledge or under such circumstances that if death be caused by that act, the offense of murder will emerge. In the present case, on the evidence of the medical expert examined, it cannot be considered that this requirement has been made. We are therefore inclined to the view that the offense, though serious enough, did not go beyond section 324 of the Indian Penal Code. It is also worthy of note that it is not disclosed in the evidence with regards to welding of evidence matter. The learning sentences, although convicted the appellants of the offense under 307, gave to them a sentence of 2 years. This judgment has been taken note of by Honorable Justice S.K. Sahu in 2021.
That I feel.
एससीडी छड़ा कोथरे रिपोर्ट है छड़ा एससीसी ऑनलाइन नहीं कि याद नहीं कि and in between by that 30 years have been passed, more than 30 years. Okay, case of 93. That has also been taken note of by the Ethics Code in 2016, volume 7 also.
Time factor.
Mallet?
Time factor.
Time factor and age factor. 20 years by that time, and in between he has settled. The Honorable Justice Deepak Mishra was pleased to release even POI. Converting it to 324. Time factor essence.
ठीक है पर नहीं है सब चीज दे दिया बेटे दीजिए वही जो किसी yes 40? No, I will deal with that. I'll deal with that.
Twenty-seven.
47. Anybody is there? छोटे मेट्रो
I have got 2-3 other matters where my learned friend says, my lord will take up small matters.
small matters because which matter you want to do, they'll have to read it and come.
My lord, so
I
that that is criminal appeal number 10 of 26 read with criminal appeal number 24 of 26.
Note down who will read. Tell me.
Here, my lord, a question that has come to my mind, but I'm not getting answer. Whether charge can be framed under 304 part 1.
Part 1.
It's not
What-
a
what
charging.
is
It's
charge
not a
rate?
charging section, my lord.
It is not charging it.
Madam.
Two can be.
Yes, my
But
lord. I'm
in this case-
not getting the
In
answer.
this case, charge is framed in the.
Yes, my lord. Initially, charge sheet was submitted under 304. I was verifying LCR.
So
Please-
check it.
I'll
Check it. If that is the case, then we can
Tuesday,
delve open that issue.
Ma'am,
That's not a charging section. That's it.
I consider that.
because
Find out.
that shows, my lord, culpable homicide not amounting to murder. That was in the mind of the court from the date of framing of charge.
See, the evidence also goes like that, na?
Ah.
Because he has made up his mind kind of.
My lord.
It is prejudicial.
Yes.
My lord.
So 464, huh?
Yes.
464,
Which
prejudice.
initiate-
Omission or error in framing of charge, if prejudice to the accused,
My lord.
then the entire thing goes.
Yes.
My lord.
So that's the prejudice part. Just check it up. Which item that is?
15. My lord.
15, huh? 15 you do it, huh? Find out some judgment.
Tuesday, your lordship.
Don't expect seniors will find out. It
Lordship,
is
I'm
you are
saying for Tuesday.
huh? Tuesday. Find out the judgment and
Because
if you get the judgment, you just tell him so that
so the
he will yes. 20.
27.
Yes, madam. 27.
So this is a conviction under section 3110 of the SCST Act as well as 323-34 of the IPC.
But conviction and sentence?
His sentence is for 6 months for SCST Act and
Period undergone.
fine for 320.
37 days.
37 days.
Second died.
Yes.
37.
Third is Ruchu Mohanto.
Rucha Mohanto.
Rucha Mohanto.
Must be around 68 years as of now.
60.
So the only problem that in
Yeah.
SCST, the sentence cannot be reduced beyond 6
Month is
months.
minimum.
That is the only.
No, Rucha Mohanto, just see the evidence. Who is
Yes.
the victim? Who is the victim? You. Just a small matter the youngster can do. Come, just find out who is the witness. Just see. Take it out. 27th, na? Huh. Take out the evidence of which witness is that?
Yes.
Victim. Now, PW1, read it. PW1 is the informant. Let us read it, PW1. Concentrate and Ruchu, huh? Ruchu, what is that? Ruchu, na? Rucha. Ruchu, it is written Ruchu here. Rucha Mohanto. Okay? Just see. I am the informant.
I am the informant. I know the accused persons about 2 years back. in the
Arjuna
month of
Mohanto
Boisa,
came there
I was
and
with-
assaulted my head with a lathi. And I was cultivating the land since long. I was medically examined
Came there and assaulted.
and a
me.
kai worth of I cast. I lodged a fire at the ears under the going so and so so. Kai worth
Kaivarta is a caste.
is a cast.
Yes, sir.
ठीक है, but Arjuna has given the
Arjuna Mohanta is the culprit. Yes.
okay.
The PW2 again said is.
Forget about the cross examination. Let us accept it to be correct.
Yes, sir.
Then it is against Arjuna only.
Yes, sir.
There are two things are emanating. One is Arjuna has assaulted.
Yes, sir.
Kaivarta, this Ruchu has not done anything.
Yes, sir.
Kaivarta is a caste, but whether it is proved or not on record documentary, this is one thing we see. Second is because he is Kaivarta, therefore Arjuna had attacked nothing else. That's all. It is only assault. It happens to be a Kaivarta. He that because he is a Kaivarta, he was attacked. The judgment which I pronounce. Intention is to- intention only because you belong to that caste. Therefore, I am doing it. That part is not there. This is except as it is. Let us come to
This
two.
is the only thing that whether any complicity of the Rucha Mohanta is there or not, that's the only.
That
thing.
we will see. But even if you accept this, these are the three things which is coming out from this
If
evidence.
PW2 doesn't say about Rucha Mohanta.
PW2 doesn't say anything. Again, Arjuna Mohanto.
Yes.
Arjuna Mohanto.
PW3 says.
PW3. Hello.
PW3 says at this, I'll read the fourth line from the top. At this, accused Arjuna Mohanta assaulted on the head and the left hand of my father by lathi, causing bleeding injury. Accused Ruchu alias Chunuram Mohanto assaulted on my head with a lathi, causing bleeding injury. Accused Vidyadhara alias Ramachandra Mohanta assaulted my brother Gajendra Sanapati, who sustained bleeding injury on his head due to assault. So there are three victims. One and this three, and the other one is Gajendra Sanapati.
Whatever, what PW3 has said
He has
that
named,
he has said.
And he says we are Koibarta by caste, accused persons are belong to the general caste.
But they maybe it happens. कोईबर्तो बोली मारला ना कौन सी?
I just
मारला कौन कौन
I
रोड़ी
just
दिला
point
मारला?
what is there, Your Lordship.
323 I can understand.
Yes, sir.
Chalo, this is the evidence. Next,
Yes, sir.
PL4, who is this?
Independent witness also.
Yes, sir. They say their name Arjuna Mahanta and they say other.
But जाति को नहीं की किसी गलती नहीं.
Yes, sir.
जाति को नहीं की किसी कोई नहीं.
नहीं.
ठीक है? चलो. आगे 5. Same.
I know all these accused persons and I've not seen the quarrel.
I have not seen the
Five-
quarrel. ठीक है.
So 5W5 is not.
How many witnesses are there?
Seven witnesses are recommended. PW7 is the doctor. PW6 is the IU.
Exhibit 3 is the caste certificate.
Yes, sir. So PW7 is the doctor, Your Lordship. He says
No, caste certificate is produced. Caste certificate maybe, but that was not the intention. Next 7
7.
is doctor, huh?
7 is the doctor. He says injury number 1 and 2 are simple in nature. but
How many injuries? 3.
3 injuries on Gokula Senapati first. Thereafter Surendra Senapati,
Okay.
2 injuries.
Let us see now. What is the conviction under?
323, 342 SC/ST Act.
323.
323 also.
Acha, who is PW3?
3 is the son of the PW1.
No, tell the name.
Yes, sir.
PW3 was examined by the doctor?
Yes, Your Lordship.
Who?
He has 2 injuries on his body.
What is his name?
Surendra Senapati.
Surendra.
Yes.
Surendra Senapati कहीं पढ़ा था?
PW6 paragraph 2.
Hmm?
No, he's Gajendra Senapati. My mistake.
Where is Surendra?
Paragraph 3.
Surendra 3.
Paragraph 3.
Gokul Senapati, evaluation segla, lacerated venticula. There are 2 injuries.
Yes.
Simple in nature.
SC.
Might
have caused by heart to weapon, the age of injury is so. Just see PW3 again, Surendra. Come to PW3. Bachu has given, Rachu has given.
At
Which
this
kind?
accused Arjuna Mahanta assaulted on the head and left hand of my father by a lathi causing bleeding injury. Accused Ruchu alias Chunaram Mahanta assaulted on my head with a lathi causing bleeding
Head, huh?
injury.
Come to 7 again. Head injury अच्छी की नहीं.
Sir.
PW7 ना?
Yes.
Head injury is there.
Yes, Worship.
Para 3 ना? Forearm. Head injury is there. Number 2.
Scalp.
Number 2. 323 बने हो.
Yes.
323 बनेगा भाई. HCST is not made out. 323 is made out.
If PSCST goes, 37 days of undergone.
37. 323 undergone करके छोड़ दो.
Aye.
HCST is not made out.
Assist is not.
Nothing
made
is made. HCST is not made out. 323 made out.
Yes.
323 ଅଛି ତ ସେ already 37 days ରହି ସାରିଲାଣି।
That part will affirm the conviction under 323 and undergone, already undergone. ठीक है.
ଲକ୍ଷ୍ମୀ ଆମେ ଯୋଉ ସେ ଇଣ୍ଟେନସନ ପାର୍ଟ କୁ ଆଇଲେ ଆମର ଏସସି ଏସଟି
Eh?
ସବୁ ସାର୍ ଇଣ୍ଟେନସନ ପାର୍ଟ କୁ ଆଇଲେ ସେ ଆଜ ପର
That is the idea of HCST.
90% କେସ୍ ପଳେଇ ଯିବ
Intention is like
It's sufficient. If intention is not there for SC/ST Commission of Office, the knowledge that he is a person of SC/ST,
then you do some act, then only.
then also that will suffice the.
Otherwise, no. Which is the judgment I have? Intention.
See the.
I'm just.
ऐसे हम देख दूसरा काली भी तो दे दो
काली
आज आज दे दो
आजर काम आज ही काली काली की I will finish it up right now.
आज दे दो
Did you follow what transpired? Did you follow what transpired now? Because you are MAK Skiri
Yes, ma'am.
and everybody is working for you now. You tell me what happened.
So there was a quarrel between, there was simple harm. Then there was allegations of remarks regarding SC and ST. But from what transpired from these exhibits, that there is no remarks regarding the caste. Only there is.
Only they have attacked without knowing whether he belongs to this card or that card. There is no intention to
No intention.
hurt him because he belongs to particular community or caste. So therefore, three offense under the special act goes.
Right.
If it goes, only the what is remaining is 323,
Right.
simple injury. And one of the witness, that is PW3, has said that this accused has given a blow in the head, and the doctor corroborates that. So 323 is made out, and he has already undergone about 37 days. 37 days. So
37.
therefore, already undergone.
The primary judgment is Swaran Singh.
Hey, 1 minute, I'll read. 37 days undergone, na? 47.
Yes, 37.
37 days.
37 days undergone, and 3 SC and ST acquitted. 323. PW 3 and 7. Okay. Which judgment you are talking about?
Swaran Singh versus State of. I'm just sure.
Appearance permit लगाओ, ठीक है? Review लोग जैसे and judgment मैडम देवेश judgment आपको रख दी उसकी बिल्कुल है evidence PW3 and PW1, 2, 3 and 7. 1, 2, 3, 7. 1, 2, 3, 7. ठीक है, इतनी दे दियो अगले दफा, ठीक है? Yes, give your name and all.
Yes, ma'am. Even.
Any small matter? Which one?
So item 40 and 42, your lordships.
40?
Item 40 and 42. 6 months imprisonment, your
6
lordship.
months.
Yes, your lordship.
40, huh? 40.
Your lordship.
Offense?
323, your lordship. Convicted under 323, but initially charged under SC/ST Act and other
Okay.
allied offenses, but only convicted under 323. And as to that part, they have examined 5 witnesses: the blind husband, the victim wife, one independent corroboration, I'm not disputing the same, and 2 other independent witnesses who have turned hostile.
Doctor?
Doctor has not been examined, investigating officer has also not been examined, your lordships. And there is
And the injury report is not brought on record.
no, your lordships. And for appellants, your lordships, no specific overt act is against anyone, your lordships.
No, injury report, then how will you know it is simple injury or whatever?
Injury report is not there, your
Let
lordships.
us,
Yes, your lordships.
let us see. Injury report is not there. IO is PW5, huh?
Not there. Your
Not
lordship.
examined.
Not examined.
Not examined, huh?
That is Swaran Singh judgment as well as the latest judgment of this.
Please give it. Huh? Yes, madam, what to do in this case? It's very peculiar thing. 323 conviction,
40.
40. See what happened is 323 conviction.
320.
Doctor is not examined. IO is not examined.
Examined.
The medical report is also not exhibited.
Paperwork also not with me.
Paperwork is not
Not
required.
with
Whatever he said,
Office.
I see the last part of the judgment. Just see, last part of the judgment. 5 witnesses are examined.
Examined.
IO is not there, doctor is not there.
Not.
And the only exhibit is the FIR.
3 and 5 hostel.
The only exhibit is the FIR. No injury report exhibited. Doctor is not examined. Hmm?
It's a 22 days.
Let's see.
As to the evidences of the
What are the facts you tell me by the time she said?
Yes, Lordships, on the earliest day, Your Lordships, the RI for demarcation of land has arrived to the spot.
Hmm.
And subsequently, these two persons, the victim and her husband, the husband is blind, Your Lordships.
Hmm.
They have reached the spot and obstructed the same that they have not sold the land. Why they are doing the demarcation procedure? And to oppose the same, to allow the demarcation going for carrying forward the demarcation, the appellant has assaulted. And the as to the FIR is concerned, Your Lordships, they have abused, assaulted, and threatened to kill the informant, and tried to do push and pull, Your Lordships.
But that's all.
Yes, Your Lordships.
And what are the injuries sustained?
Your Lordships, injuries have not been brought in the evidences also, Your Lordships. No specific overtake against anyone, Your Lordships.
EW1 says the accused persons assaulted me and my husband with his sticks and they tore my clothes and they abused us within filthy language.
Take it.
And the cross-examination has been declined.
That's the problem. These people, it has gone unchallenged. Therefore, the trial court says that it's gone unchallenged. What?
In PW, all the accused persons assaulted to
Again, decline.
declined.
Decline.
So that is intact.
Decline. Third has to decline.
PW is declined.
Everything is
Please-
declined.
Please read PW.
The same prosecution.
3 and 5.
Yeah, PW3, Your Lordships, I may read. And all the accused persons, they are.
Everything I have ready.
I went to the spot after
Don't
the
take
other
much
report
time.
was
Yes,
in the
yes,
video.
yes.
And if you have declined, why should they examine? Either the doctor or you have accepted it.
Because 1, 2, if they accepted the word.
Then further is not required. That's why that is very.
Judgment page number 4,
And
the
for
court also in the
4 also, he has a, the accused person is assaulted to me and my wife. He is a victim and cross-examination.
Get me a judgment Tuesday
Yes, Your Lordship.
that in the absence of any medical evidence,
Yes, Your Lordship.
bringing a record whether it is a simple injury or grievous injury, what is the nature of injury? 323 or for that matter 324, 25, whatever is not made up.
Yes, Your Lordship.
So merely saying that the victim says that I was beaten up, if the evidence is gone unchallenged,
Yes, Your Lordship.
in the absence of medical record,
Yes.
because it could be a grievous assault also.
Yes. Understood.
It can be 324 also, it can be 325 also.
Yes.
Why 323?
Yes.
323 can be done on the basis of some medical evidence. In the absence of medical evidence,
Yes.
whether 323 can be,
Yes.
the conviction can be maintained or not. Okay?
Your Lordships, I will
Because
just
medical evidence is not proved. IO is not.
I may press one part, Your Lordships. As to PW3, Your Lordships. I know all the accused persons and the victim. They are my villagers. The occurrence took place around 7 years back. I went to the spot after the occurrence was over. I had not seen any injury on Sapani and her husband.
The 1 to 4 is there who is supporting and where the victim.
That's the problem. You have declined to cross-examine.
Yes.
in the judgment page number 4, the court observed that in this case nothing was put to the witness to the effect that they have a different version before the IO. In
That's
other
right,
words,
I have seen it.
contradiction exists in the evidence of the
I've seen-
witness. So non-examination of the IO in no way affects the prosecution case.
Yes.
The decision reported 1994 to crime.
Yes, that's
There is-
reasoning is correct.
Yes, Your Lordship.
That has been been discarded only because the investigation has performed.
The reasoning is correct, not that.
Unless it is shown by the.
The only thing is that, that part.
Hmm.
In the absence of medical evidence,
Medical-
how will you arrive at a conclusion that he sustained simple injury or grievous injury, whatever?
How can-
Yes, Your Lordship. I'll find it.
Okay.
Yes, Your Lordship.
You get the judgment.
Yes, Your Lordship.
First item,
Yes, Your
Tuesday.
Lordship. Yes, Your
Come with
Lordship. Yes, Your
judgment.
Lordship.
You should have come with the judgment. That is the basic thing.
Lordship, I have researched, but I have not.
Read
taken
that
the-
judgment and find out. Huh?
Yes, Your Lordship.
Find out.
51 40 years, 51 2 months.
2
51 item, 2
Hmm.
months only.
2
But-
months.
Yes, sir.
Undergone period?
42 days.
42 days.
Yes, Your Lordship.
Already undergone.
Yes, Your Lordship.
2 month sentence.
2 months only.
So because remission, they'll get remission, na? Certain remission.
Maybe.
51.
2 months means 8 days remission.
Again.
That is 50.
Age delivery 52 32 ଅଛି.
Like total 2 month sentence,
2
na?
months and 60 days.
60 days,
Minus 8 ହେଲା ମାନେ 52 ହବ.
52, 10 days divorce.
42 ଅଛି.
Offense?
Offense is under section 23 and 342. 2 months is run concurrent years.
Why these people are not coming here? This lawyers are not coming. What's the problem? 2010 for it. Who is the lawyer? D.N. Mishra. But I tell you in the year 2010, 45, 57, 39.
PW 1 to
1 to 5.
Who?
1 to 5 in this case are turned hostile.
50.
51.
51. How many witnesses are there?
12.
12 witnesses.
8, 9 are the star witnesses who are the victim of the.
No, not 12 witnesses. 5.
Item
No,
51.
51 years.
51. Criminal appeal
554.
Number
575.
554.
575.
554.
No, that's not D.N. Mishra. 50.
51.
51. Yes. Or none appeared here. Yes.
12 witnesses, 8, 9 are the star witness, and only 6 is the doctor, 12 is the IU.
Sentence is 2 months. Hmm? Hmm.
Either last.
So, evidence ಕೂಡ ಕಡೆ ಇರುತ್ತೆ. और एविडेंस करके देखते हो आई अपॉइंट समवन मैं किस करूँ ट्यूसडे लगेगा ट्यूसडे दे दो एविडेंस करके ठीक है ट्यूसडे विल टेक अप ट्यूसडे विल टेक दे दो अभी जितना हुआ दे दो